homicide, suicide, or accident. The evidence in this case has shown that these are the three plausible manners of death that could explain how Miss Saria Hildabrand passed away. Homicide, suicide, and accident. At the beginning of this case, I told you, this case involves the tragedy of a young woman's life being lost to an accident and the story of a scared young man. You've now heard all of the evidence in this case, and I submit to you that it is reasonable to believe that Saria's death was an accident. An accident that was not caused by Mr. Hildabrand, but unfortunately by Saria herself. And because there is reasonable doubt in this case about the manner of Saria's death, there is reasonable doubt to every theory of homicide that the government has presented you with. From intentional murder to criminally negligent homicide, there is reasonable doubt about the element of causation. Every one of those theories, murder 1, murder 2, manslaughter, and criminally negligent homicide, all require you to find as a jury that the government has shown through proof beyond a reasonable doubt that Mr. Hildabrand caused the death of Mrs. Hildabrand. And I submit to you, there is doubt about cause because there is doubt about manner. What is reasonable doubt? A reasonable doubt is based on reason and common sense. But there are times where common sense is betrayed to trauma, leading to choices that in hindsight are objectively wrong. This is part of the human experience. And you have seen that in this case. What other human experiences have you seen demonstrated throughout this case? Let's talk a little bit about lying. You've seen quite a few lies in this case. You saw Marie, for example, admit that she lied to Mr. Rice. And Marie's motivation to lie at that time was because she wanted to get information. Who else did we see lie? We saw Detective Clark admit that he lies based off his training and experience in the course of this investigation. And the reason Detective Clark lied is to try and get information efficiently. Lies can show a lot of things. What's important is what is the motivation for the lie. The government would have you believe that a lie must be evidence of guilt. I submit to you that lies can mean a lot of things, and they don't always mean guilt. No one here thinks that Marie is guilty of a crime, even though she told a lie to get information. No one believes Detective Clark committed a crime, even though we know he told a lie to try and get information. And I submit to you that the mere fact that Mr. Hildabrand has lied does not mean that he is guilty. What you need to look at is the motivation behind the lie. And that is what this case is about, the fear. In his panic and fear, Zarrius made some mistakes, some abysmal choices. But these choices and mistakes should not be seen as evidence that Zarrius killed his wife. They should be seen as evidence of what they are, evidence of fear. And what was reasonable at the time that Zarrius did the things that you heard him say he did was that fear. I submit to you, you need to look no further than the opinion of the medical examiner, the biased Detective Clark, and the state's closing argument to understand that fear. Fear. So why was Zarrius' fear reasonable? What was Zarrius afraid of? He was afraid of being accused. When he woke up, he did not know what happened the night before. The government wants you to look at a timeline and wants you to believe that Mr. Hildabrand was immediately looking at pornographic materials after he found his wife deceased. But go back and listen to what Mr. Hildabrand actually said. When Mr. Hildabrand woke up, he looked for his phone. He couldn't find it. But Saria's phone was there. Mr. Hildabrand got out of bed, used Saria's phone to call himself. He called himself twice. And those calls were not answered. I submit to you, it is reasonable for a person to call themselves when they can't find their phone. Then what happens? Mr. Hildabrand can't remember what happened the night before. So he goes and he looks in his phone. He can't remember everything he looked at because this happened almost 3 years ago. Because he was still drunk when he woke up. And because what would happen next was a traumatic experience. And I submit to you, use your reason and common sense here. Trauma affects people differently. Trauma affects memories. Trauma affects our ability to recollect and perceive things. The government wants to call Zarrius a coward because he can't remember everything perfectly. I submit to you that just demonstrates the government's bias in this case. Mr. Hildabrand looks through his phone. It's likely that in that process he went on the Bush Company website before he finds Saria. What else does he find when he looks on his phone? He finds the Snapchats, and he knows, uh-oh, I'm busted. And that's what the government wants you to believe is a motivation to kill someone. Snapchat and Instagram photos. But that's not what Zarrius did. Zarrius went to go talk to his wife about these photos to try to make it better. And that is when Zarrius discovered that his wife was deceased in their bed. That is when the panic and the fear hit him. What was the first thing he did? He checked for her pulse. If he had killed her the night before, why would he check her pulse? You would think he would have known that she was deceased. But he checked for her pulse. And then there's panic and there's fear because he doesn't know what happened. What will people think he did? That was a reasonable fear. And Zarrius wanted to protect the people he loved from the pain of having someone that they care about be accused of doing something horrible. Zarrius wanted to protect himself. And Zarrius made objectively bad mistakes trying to do so, trying to protect the people he loved, trying to protect him. That doesn't make him a killer. So let's talk about what the evidence in this case objectively shows. Let's talk about Dr. Gallagher. I want to talk about Dr. Gallagher's opinion. And I want to talk about why you should not rely upon that opinion in deciding if the manner of death in this case was actually a homicide. So we go back to Dr. Gallagher's testimony. If you recall, the main thing the medical examiner does, a pathologist, is they determine the cause and the manner of death. If you remember, cause is the medical reason for death. Manner is the how. Manner looks at the reasons beyond medicine, circumstances surrounding the cause of death. Cause of death is not in dispute in this case from the pathological perspective. It is undisputable that Saria died from a single gunshot wound to her head. What is in dispute here is the manner of death, the how. How did that gunshot wound happen? And we learned a lot of things from Dr. Gallagher. We learned a lot about pathology. We learned from a pathology textbook. And what we learned from Dr. Gallagher is that there are multiple classifications for manner of death. We have accidental, homicide, suicide, undetermined, and natural causes. And in this case, we learned that the accidental manner of death could include the taking of one's own life unintentionally. Accident can include the unintentional taking of one's own life. We learned that Dr. Gallagher is busy. Yes, he has training. Yes, he has experience, but Dr. Gallagher is a busy guy. We heard he does somewhere around 250 autopsies a year. Think about how many autopsies a day that would come out to in working hours. We heard that his memory is not always the best. He had a hard time recalling a conversation that Dr. Gallagher and I had just a few months ago. Not because he's trying to lie, but because memory fades over time. And Dr. Gallagher is busy. We heard that Dr. Gallagher writes reports. He relies on those reports, which is fair. When you're that busy, you need to be able to document and refer to things. But Dr. Gallagher is so busy that he doesn't have time to correct typos. And as a result, in this case, there was an error in his report. What else did we learn from Dr. Gallagher? Language varies in pathology, at least according to one reliable treatise. And you heard Dr. Gallagher read from the treatise in this case into the record. And I want to take you back to some of the things that we learned from Spitz and Fitcher's Medical Legal Investigation of Death, the 5th edition, a textbook on pathology. The terminology most often used to describe the range of fire is as follows. A contact shot, when the weapon is fired with the muzzle in contact with the body. A close range shot, when gun smoke is deposited on the target. And a distant shot, when the muzzle to target distance exceeds the limit in which gun smoke is identifiable on the target. That is the textbook language. And Dr. Gallagher was familiar with the textbook language, although he does not necessarily use it in his practice. He knew what a close range shot was. He told you he doesn't use distance range in his practice, but he knew what a close range shot was. We learned about range of fire from Dr. Gallagher. And range of fire would be defined as the distance from the muzzle of the gun to the object, correct?
Yeah.
And for a close range shot, some circumstances, a close range shot could be ruled a homicide, correct?
Yes.
Some circumstances, a close range shot could be ruled a suicide.
Yeah.
And in some circumstances, a close range shot could be ruled an accident.
Yes.
In some circumstances, a close range shot can be an accident. What else did we learn from Dr. Gallagher? We learned that the distinction between homicide, suicide, or accident may be difficult and sometimes impossible. Certain criteria are used by pathologists to define the manner of death. Among these, evaluation of the range of fire is of the utmost importance. What else did we learn? We learned that accurate assessment of the range of fire requires test firing of the gun with the type of ammunition that was used in the shooting. We learned that the approximate distance from which a close range shot was fired can be evaluated only by test firing the particular weapon using the same type of ammunition as that used in the shooting case under consideration. Why does this matter? Because the evidence shows that Saria died from a close range shot because there was stippling. Gun smoke was deposited in the area around her forehead. We learned from Dr. Gallagher that a major factor of his opinion on Saria's manner of death was his personal assessment of the range of fire.
Do you recall me asking you the question, besides the stippling and your determination that this was an intermediate gunshot wound, what other facts were you relying on to determine that this was a homicide, classified as a homicide? Do you recall that question?
Not particularly, but we, all of our cases are signed out with review of the autopsy findings, toxicology findings, investigative findings, and medical histories if they're pertinent. All that's put together before the certification to determine the cause and the manner.
And you recall in that conversation responding to that question, Well, certainly, like you mentioned, where she was found is certainly an unusual location, but the main finding of a gunshot wound that is further away that an individual holding the gun should be able to accomplish on one's own self is a major factor in the determination of the manner. Do you recall making that statement?
I agree with that statement.
Do you recall me? She was found is
Range of fire was a major factor in Dr. Gallagher's opinion. But if you recall from Dr. Gallagher's testimony, he based his assessment of range of fire not on a test fire, but on his training and experience, and I'm looking at the sibling. If you recall, he also said that he would defer to a ballistics expert if their opinion was different. If you recall, he estimated that the range of fire in this case was approximately 2 feet. But what did we learn from Miss Castle, the ballistics expert, the person who actually did test fire? We learned from Miss Castle that the muzzle to target distance was not contact, up to 12 inches, most likely 6. Saria died from a close range gunshot wound. From not contact to 12 inches to 6 inches from her head. We also learned from Miss Castle that the gunshot was slightly upward. Why does this matter? Because when it can be next to impossible to distinguish between homicide, suicide, and accident, and determining the range of fire is of the utmost importance, the range of fire in this case matters. And Dr. Gallagher's opinion on matter is not reliable because Dr. Gallagher's opinion on the range of fire was not accurate. Dr. Gallagher has a lot of training and experience, and we learned a lot from him. But we also learned he did not do the muzzle to target distance testing. He did not go to the crime scene alleged by the government, and he came to a manner of death based off an opinion that was not correct. Homicide, suicide, or accident. We cannot rely on Dr. Gallagher to say that this was a homicide. The government wants you to believe this was a homicide. They want you to believe in motive. They want you to believe that Mr. Hildabrand was able to get a gun 6 to 12 inches away from his wife and kill her without leaving a single defensive wound on Mrs. Hildabrand. And let's talk about the circumstances surrounding 2:48 a.m. Let's talk about what led up to that. Let's talk about Mr. Hildabrand. You heard from multiple witnesses, both from the state and the defense, that Mr. Hildabrand is not a violent person. And that was never contradicted. The government could have contradicted that if they had evidence of that, but you are allowed to consider the absence of evidence. So what do we know about Mr. Hildabrand? We have uncontradicted evidence from multiple people in this case that he was not a violent person. In fact, we heard that when he gets upset, he shuts down. Not a single witness ever heard fighting or arguing from that apartment. You heard how officers canvassed the area. You heard some left cards, they get calls back, they knocked on doors, they talked to people. Not a single neighbor heard an argument that night. Or ever. We heard that although Mr. Hildabrand makes mistakes when it comes to cheating, Saria had gotten over those. They were, for the most part, a normal newlywed couple. And on August 6, 2023, at 12:07 a.m., that was done. Mr. Hildabrand, clearly intoxicated. Saria, happy with him. The government wants you to believe that they went from Plaintiff's Exhibit 297 at 12:07 a.m. to Plaintiff's Exhibit 298 at 12:55 a.m. What did you hear about Zarrius? What do you see? Zarrius was so intoxicated he could not get into the gaslight. The gaslight. He threw up in the Uber. He is sleeping. He threw up getting out of the Uber. He had to get help inside of the apartment. And they want you to believe that by 2:45 a.m., a mere hour and 55 minutes after this nonviolent person turned into a man who was mentally able to form a conscious objective and physically able to take a gun and get himself 6 to 12 inches from Saria's head while she's on her bed and pull the trigger again without leaving a single defensive wound on Saria. In an hour and 55 minutes from that. And they want you to make that determination not on evidence. They want you to believe there was a fight. And that is where the bias comes out. The bias that has permeated this case from the beginning. The bias because of an opinion that Mr. Hildabrand doesn't act like a normal person. What is a normal person? What is a normal circumstance? Was this situation that Mr. Hildabrand was in that morning, was that normal? There simply is not a normal response to what Mr. Hildabrand told you he found on August 6th. You heard the government call Mr. Hildabrand selfish. You've heard them call him a coward, a narcissist, because they don't think he's normal. But think about what was really going on that night. To believe the government's narrative that this could be an intentional homicide, an intentional murder, makes about as much sense as believing that Saria's death was a suicide. Homicide, suicide, and accident. There's no motive for murder. This isn't a suicide. So what does that leave us with? With the evidence in this case, with the 6 to 12 inch range of fire. What does that leave us? Accident. And what evidence supports that this could have been an accident? What do we know? We know Saria was awake. She was awake. She was sending text messages to herself. She was taking screenshots on Mr. Hildabrand's phone. And the reason Miss Saria Hildabrand had Mr. Zarrius Hildabrand's phone is because Zarrius was not awake. Because Zarrius keeps his phone on him like any other 21-year-old, glued to their phone. How do you know Zarrius was asleep? Because Saria had his phone. The evidence is clear that Saria had his phone. Saria was the least intoxicated. We heard evidence and testimony that the firearms were not in their normal location. We heard that when the firearm was found, the safety was off. We heard that both Saria and Zarrius used this gun. And we heard that the direction of ejection was up and to the right. And so every time the government has talked to you about what this could have looked like, they want you to think this. I submit to you that this was an accident. Saria had the gun. She went to the bedroom. She was messing around on it and accidentally discharged the firearm. Not intentionally, but accidentally. Up. And to the right. That is what Ms. Castle testified to. And how do you know that Zarrius was asleep when this happened? Well, look at his cell phone records. Look at Saria's cell phone records. Look at the gap in time of movement. On August 6, 2023, in the early morning hours. There is a brief moment after 2:48 where Zarrius' phone moves. What do we hear? where were Zarrius' pants in the morning? He woke up in his underwear, and his pants were not in the bedroom. They were over by the bathroom, and they were wet. Sir Hildabrand was so drunk he tried to get up and go to the bathroom and couldn't make it. He was so drunk he didn't know what happened to his wife that night. And the absence of any movement on those records in the hours directly after the 911 call show Zarrius was not functioning until he woke up and called himself on his phone, on Saria's phone. Homicide, suicide, or accident. Zarrius told you he didn't know. Zarrius made a lot of mistakes. He did a lot of thoughtless things. But his fear was reasonable. It doesn't make what he did reasonable, but the fear, that was a reasonable fear. And he told you the mistakes he made. And if he was lying to you, don't you think a better lie would be, I didn't do it? It wasn't me? Not, I don't know. He doesn't know because he has no memory. And not a single witness could tell you that they saw who pulled the trigger on that gun. Homicide, suicide, or accident. This case is about reasonable doubt because this could be an accident. Reasonable doubt isn't based on what normal people do. Reasonable doubt is based on reason and common sense. It is based on the absence of evidence. And so I want to talk a little bit more about juror instruction number 3. There's no saying that you'll never really understand a man until you walk a mile in their shoes. And in this trial, you have heard from Zarrius. You have heard of his fear and shame. You've observed through this trial a mile of Mr. Hildabrand's mistakes. But none of those mistakes were murder. The fundamental obligation of jurors in a criminal trial is to apply the presumption of innocence and the burden of proof beyond a reasonable doubt. We talked about this in jury selection. We talked about being objective. We talked about taking an oath. And you all did take an oath in this case. And in jury selection, I talked to you a little bit about the different standards we have in law. I didn't talk to you about probable cause. But we've heard about probable cause in this case. Probable cause is the standard that applies when the government wants to get a warrant to search a home. Probable cause. We've heard, when we were doing jury selection, we talked about preponderance of evidence, if you recall that. Preponderance of evidence means more likely than not. 51% chance. Probably. Likely. But it's not enough that you believe a defendant is probably or likely guilty. In jury selection, we talked about clear and convincing evidence, which is more than a preponderance, but lower than beyond a reasonable doubt. We talked about different areas of law that clear and convincing can apply. We talked about how in non-Indian Child Welfare Act cases, clear and convincing evidence is what is required for the government to show before they can terminate the legal relationship between a parent and a child. It requires strong probability. And we know that reasonable doubt requires more. It is not enough that you believe a defendant is probably or likely guilty, or even that the evidence shows a strong probability of guilt. The law requires more. And there's just not more here. Homicide, suicide, or accident. Those are the three plausible manners of death in this case. And Saria's death could have been the result of a self-inflicted accident. It's a reasonable inference to draw from this case. Don't get distracted by the emotion. Mr. Hildabrand simply asks that you do what you said you would do at the beginning of this case, when you took your juror oath. I ask that you be objective. Don't let your emotion distract you from the doubt in this case. Mr. Hildabrand made mistakes, and he owned those mistakes in front of you. Those mistakes don't make murder. Objectively, the government has not shown their case through proof beyond a reasonable doubt. And that is why we ask, when you go back and deliberate, to take your time. There is only one verdict that should be returned in this case, and that is not guilty on every count. Thank you.
Ms. Dunlop?
Yes, sir.
defendant would have you believe that this case is about a series of just unfortunate choices and mistakes. What a belittling and trivializing way to think about this. The defendant cheated on his wife, he got drunk, he got caught, he pulled a gun on her, he pulled the trigger 6 to 12 inches from her head. And then he cleaned up the apartment, he searched porn, he drove all over town getting cleaning supplies in a 96-gallon garbage can, and then he dumped her body in a storm drain. And then he reported her missing and walked through the woods with her mother searching for her. These are not choices and mistakes. These are evidence of intent, evidence of intentional murder. To say that he did not know what happened, it is frankly what he has to say because he's caught on video all over town, right? Like, we know that there's only 2 people in that apartment, no matter how many people Miss Brewster asked if they heard or saw the gun being fired. We know there's only 2 people in that apartment. To say he didn't know is unreasonable. First of all, it's not a defense. Like I talked about, you can do things in the moment and not remember them later. And if you meant them in the moment, you're still responsible. And that at best gets him to murder in the 2nd degree, but that's not what happened. It is unreasonable to think that a 9mm weapon went off inches from his head and he didn't hear it. The neighbor across the courtyard is calling it in, but he didn't wake up to this tragic accident. That's just not what happened. It's not reasonable. Ms. Brewster has said many, many times there's no evidence of a confrontation, that they fought about this. You don't have to have a loud yelling fight to have a confrontation. There's no evidence that Saria was a loud yelling person. The evidence of the confrontation is the messages on Snapchat that she clearly sent to herself. The evidence of the second woman that she, for all we know, didn't know about before she saw the Instagram messages, and the bullet in her head. That's the evidence of the confrontation. So let's talk about whether this is an accident, whether Saria just handled this gun and accidentally shot herself in the head. There's no evidence at all that she ever handled the gun. 0. The only evidence we have is the defendant says she's fired it before. We don't have her DNA on the gun. We tested it. Nobody's ever seen her other than him with it. There's no evidence that she ever handled the gun. We also know she's not terribly drunk. Why would she be playing with it? Why would she pick up this gun in that moment? No rational reason for it. What we do know is that guns are on the defendant's mind. He's searching them all day that day before they go out, all kinds of different armors. He's looking at Springfield XDs, and he's looking at this particular gun manufacturer at 3:42 in the afternoon. Guns are on his drunk mind. He's the one that has it in his hand. And she's trained and professionally trained in handgun usage. The idea that she would have this kind of accident doesn't make sense. And his response to it is the main thing that proves it wasn't an accident. If it was an accident, you don't think, man, people are gonna think the worst of me and think that I did it. That makes no sense. It's not that he's not normal, he's not reasonable. And that's what reasonable doubt comes down to, right? We're gonna put 12 of your heads together, use your common sense and your reason, what you know about the way the world works, and say, is this explanation reasonable? And if it's not, you do not have a reasonable doubt. It's not reasonable to think it was an accident that he slept through and woke up to in the morning. And then the final thing I want to address, because this is really an important evidentiary point that is just grossly misstated, is the Dr. Gallagher Samantha Castle testimony. When the defense talks about the ejection pattern, that's the pattern of the shell casing leaving the gun. That is up and to the right. That is different than the trajectory of the bullet into her head. The trajectory of the bullet into her head is what the medical examiner looks at. And the medical examiner looked at that and he found that it was front to back and minimally upward. And I'm not gonna show the photo again, but you can look at it. You can see where it goes in and where it partially exits. It's front to back and just ever so slightly minimally upward. And it's on the left-hand side of her head. Right and upwards is the ejection pattern of the casing, and that's the ballistics expert's testimony. And you really have to listen to the medical expert and the ballistics expert together. It's what the cross-examination was all about, right? Like, this is your opinion, doctor, but would you defer to a ballistics expert who did muzzle to target distance testing? And he said yes. So in his experience, he's like looking at 200 dead bodies a year. Like, we can discredit that and say he's really busy, too busy to do a good job, or we can say, man, he's really experienced and has seen a lot of suspicious deaths. And he has, to a high degree of medical certainty, have to classify that death as homicide, suicide, accident, natural causes, or undetermined. Undetermined is an option he can choose and does choose. And he said homicide. And he said homicide because this is unlikely to be self-inflicted because of the distance. Just like Detective Clark said, he's responded to hundreds of suicides and there is always a contact wound, and this wasn't a contact wound. And it wasn't a close contact either. It is 6 to 12 inches out. Now the medical examiner might on his own put it a little further out than the ballistics expert, up to 2 feet. He said intermediate range, up to 2 feet. But he said, I would defer to the ballistics expert. And then the ballistics expert does her testing, and she says, yep, 6 to 12 inches. And when I heard that this might be self-inflicted, I tried to see if I could do that, and I couldn't. Like, she couldn't possibly hold the frame and pull the trigger in a comfortable way for it to be self-inflicted, to be front to back, slightly upward with her dominant hand or with her non-dominant hand. The only way you get that is maybe by thumbs. But like, why? Why would Saria be doing that? That isn't reasonable. There's no evidence she ever touched that gun at all. The defendant is searching and thinking about that gun before they even go out. It is on his mind, not her mind. He is the one that was caught cheating. He is the one that cleaned up and grossly handled Saria's body and dumped her in a storm drain and searched the woods with her mom, pretending that she was missing because he was afraid. Because he was afraid that he would get caught, not because he was sad about some tragic accident that befell his wife, but because he acted on a drunken impulse when he was backed into a corner. Ladies and gentlemen, that is murder in the first degree. It is not an accident. It is not a series of poor choices and mistakes. It is intentional murder. It is extremely reckless murder, murder in the second degree, and it is 2 counts of tampering with evidence. Thank you for your time and attention, and I recognize that this is a difficult case to work through as far as the facts and the evidence and the trauma of what happened.
Objection. Overruled.
But the state trusts that you are all going to go back into that jury room and use your common sense and reason and think about what a reasonable person would do in this situation. Evaluate all of the testimony, medical testimony, the expert testimony, and most critically, the defendant's testimony, and find that he's guilty of all the counts charged.